Welcome to our podcast. As today we have as our dear guest Mohammed, Lena, and Kitty. All of these three are participants in the three-country seminar of this year, 2022, in Göcek. To all of you at the beginning, what were your expectations about the law comparison? Did you have any prior experience with law comparison?
Yeah, I have been on a project like this before. We can identify the shortcomings of our system and regulations and make recommendations to the legislator.
Okay, quite interesting. How is in your perspective, Kitty?
I have never experienced something like this before because I have never been on this conference before, and I think this is a good opportunity for me to practice my knowledge, and maybe I should just take part in it sometimes.
Okay, so you're quite without any special expectations, so quite open-minded.
I didn't have any expectations. I just came here and decided to work with you, and that's why I am here.
Okay, we're happy to have you here. Lena, what can you tell us?
I don't have any experience with legal comparison either so far, so my expectations were pretty much to just learn about different comparison methods and also just to get to know other legal systems. And I think, this is a great place to start the seminar.
Thank you all. As we all learned, a huge part of law comparison's function lies in the realization of differences which may be caused by different languages, understanding of words, and cultural backgrounds. Lena, you may start first. Did you have any struggles with your different backgrounds? If so, how did you handle them within your comparative work?
I think one of the biggest struggles for all of the groups was just the language barrier, so we had to establish some terms and definitions beforehand so we wouldn't just talk about different things. What I wouldn't call a struggle, but maybe something that we experienced a lot, I think, was surprise, just about how other legal systems are dealing with digital technology. So that was for me a big part.
Due to our time frame, we're moving over to the topic of our comparative work. Mohammed, what did you analyze?
We have analyzed video and or audio transmission in case of removal of the accused from trial.
Oh, that sounds like a very complex topic. How did you go about this analysis process?
We have determined some topics for our comparative study. First of all, term and definition, then research aim, object and comparison, method of comparison, and comparative work.
That sounds quite systematic. We already went over the framework of the project. On the second step, you identified the aim of the research by defining a leading and critical control question. Kitty, with which lead question did you come up with?
We came up with the idea to talk about, in our digital era, what is the role and relevance of attendance rights duties in criminal procedure. In this part, we want to talk about the aims and legal principles and replacing physical attendance, what kind of aims, opportunities and disadvantages it has. While our critical control question was how did the pandemic as an exceptional situation influence this? We are focusing here on the rights and duties of the accused mainly.
Interesting. And what is the function of the critical control question? So you want to, if I understood right, you want to test your theory in an extreme situation, right?
Yeah, we just gave it a name like stress test.
Okay.
If I may add something.
Sure.
I think what our biggest motivation to find a concrete lead question was to avoid just putting the legal system's provisions next to each other, which is why we came up with this a bit more abstract or general question. And then, as Kitty said, the control question was supposed to be, or is supposed to be, our stress test.
Okay, so we have two different kinds of questions. The identified questions are hardly influenced by the object of comparison, which you defined in the third step, if I'm not wrong. Mohammed, can you tell me anything about the object of your comparison?
Yeah, sure. The subject of our study is the persons attending criminal trial. These are accused, victims, witnesses, and experts. These persons take part in the trial and have certain rights. For this reason, it is necessary to examine whether video transmission violates the rights of these persons who are the subjects of the trial.
Okay, so you focus on the importance of the rights of the accused and the witnesses and so on in the trial. Can you add something to that? Maybe was it clear for you all that this is the main focus you want to evaluate?
It wasn't clear from the beginning, as we had a bigger discussion also about the principle of publicity, so the attendance of a public audience in the criminal trial, which is also a main point when talking about attendance in criminal trials.
Sure, yes.
But we then decided that it was just becoming too much. So we tried to focus our work just on the attendance of the accused, and also then maybe just as some side notes add to witnesses and experts.
I just want to add that it will be great that we can just work with witnesses and experts too, but due to lack of time, it's impossible now.
Yeah, I mean, we only have 1 week. Yeah. Okay, thank you. So on the fourth step of the steps you took in the analysis process described by Mohammed, you agreed on a method of comparison. The method of comparison is a core element of the comparison work, as we all know, and it defines heavily the outcome of the whole process. Lena, which method of comparison did you decide on and why?
So in the very beginning, if I may describe our process a little bit, we were thinking about using our stress test question as some kind of method, but we then realized that focusing just on extreme situations might not give us the general results.
Yeah, they cannot represent the reality
exactly,
at the end. Yes.
Exactly, yes. And so we try to look at the established methods, and we're starting with the legislative comparison at first, but I think in most comparative work that's the first step, to just take a look at the legal provisions and so on. And we then kind of landed on a partly functional comparison, so comparing the importance of the attendance principle and its implementation into national law.
Mm-hmm.
And then, thanks to some advice from our professors, we also included a part of the theory of operative functionality from Fateh Mukarram, which is the functional comparison plus some additional elements of culture and society. Because we were kind of constantly wondering, for example, why Germany is so reluctant in using digital techniques, and we wanted to add some cultural elements and also some constitutional elements.
So you realized one main part of comparison work is the background, the culture. It heavily influences. So it sounds like you have a very good idea, like to also include the cultural aspect. Now that we went over all the four steps of your comparison work, did you come up with any results? Maybe you, Kitty, can start first.
We made a comparative work regarding the next questions, like attendance rights, duties of the accused in general, and what kind of exceptions it has. We just talked about the possibility of video transmission in criminal trials, criticism of attendance restrictions from national perspective, and influence of the pandemic in the criminal law.
That's quite interesting. Lena and Mohammed, can any one of you maybe add something to this in regard to the possibility of video transmission in criminal trials?
I want to add this. All countries emphasize the principle of publicity. However, in some countries, the exceptions to this principle are more broadly regulated, while in others they are more strict. Video transmission is also available in the systems of all three countries, but again, the conditions for its use are different.
That's interesting. So we can see that although we might have the same idea, or we don't have the same idea of for example, the publicity aspect, we still regulate it very differently. Lena, can you add something to this in regard to the possibility of video transmission in criminal trials?
Yeah, so I think the biggest realization was how strict Germany is regarding the usage of video and audio transmission in a criminal trial. I think if you two agree, our biggest result was just how...
I absolutely agree with you.
Okay, how strict Germany is and how liberal, for example, Hungary is.
And where is Turkey in all of this? Like in between you, is it also very liberal? Is it very strict?
Turkey, I think, very liberal.
Okay.
I think it's closer to Hungary.
Okay.
Yeah, definitely.
But is it are you on the same level, or is it in the where if you create for example, a diagram, would it be on the left is very strict Germany, on the right Hungary, very liberal? Where would you locate yourself? Is it all the way over at Hungary, or in between, more to the right, more to the left?
Maybe more to right.
Okay, but not on the right with Hungary.
Maybe on the right third.
Okay.
Yeah.
Interesting. But I mean, this whole thing does probably not go without any criticism, does it? Did you know, any one of you, anything about that? Are there any opposing opinions, maybe in literature or in public?
I think that's already kind of the cultural context part of our work, which is also partly legal because it's constitutional.
Mm-hmm.
So I think the biggest pro for all of the countries was the principle of efficiency. So of course, using video transmission can make a trial a lot more efficient. But from the German perspective, there's a lot of criticism, or there are lots of threats to be seen. For example, that the principle of attendance is very significant. And there's also the principle of directness and the principle of publicity that might be affected. And then to the more cultural part, there's always the threat of manipulation, for example, via deepfakes, and the availability of stable internet connection and the technical preconditions.
Especially in Germany, you cannot count on it.
Yeah, definitely.
Okay, so there are clearly a lot of pros, like for example the how fast we can prosecute someone, but also of course the factual problems of the infrastructure. Moving over now, due to our time limit, to our control question. How did the pandemic influence the attendance principle? Kitty, Mohammed, whoever wants to start first.
In Hungary, so the pandemic just created a new situation in Hungary, and it just delivered a new regulation system. I mean that there is some other circumstances that just came up, and I can just tell that
your country easily adapted to it, so they adapted the circumstances, and whether they were quite, as we already stated, liberal with doing that. Okay.
As you say, Hungary created a 3-step regulation.
Mm-hmm.
It just means that if there is any obstacle just to use video or audio transmission, the court, the prosecution office or investigator authority can use this method.
Oh, really?
And it's obligatory to use.
Okay. Wow.
If this option is not available for them, they just have to postpone the act.
Okay, so they, instead of like forcing the accused to come, they're just like, okay,
there was no personal presence.
Okay, wow, this is quite extreme for, but I mean, an extreme case of being liberal, if you might say it like this.
Let's maybe call it flexible.
Or flexible, yes. How was it in Turkey?
Actually, there is no new regulation in the pandemic because our video transmission regulation was introduced 2013.
Oh, so you were already prepared for it.
Yeah, but our legislator tends to expand scope of video transmission.
Mm-hmm.
For example, it is aimed to establish video transmission system at large airports. And because our legislator looks at these video transmission systems ending of criminal trial in reasonable time,
Mm-hmm.
and high workload of courts.
Yeah.
In Turkey.
Okay. Do you want to add something from your perspective? Has there anything been in Germany?
Yeah, Germany there hasn't been anything in Germany, so they've been very consistent. The pandemic did not cause an extension of procedural regulations regarding the principle of attendance. And I think the pandemic also didn't really influence the legal understanding of the principle of attendance. So maybe the cultural understanding. So I think pretty much everybody has gotten used to Zoom or Skype or whatever kind of system over the past years. But German legal procedure did not.
Germany is an exceptional situation.
Yeah, I mean, they're very resistant to change, it seems. Okay, so moving on to my last question for you. Lastly, I'd like to know if the differences you realized root from the cultural differences of each of your respective countries, or do you have any other point where you think, okay, this might be the reason why we differ so much? Is it more cultural or is there something else?
I think, as I said before, there's both a cultural and constitutional background to this. I think they also influence each other, but with the German strict understanding of the principle of attendance, it was not really a possibility to be flexible with attendance in court. So there was, they found other ways to include the public and to get everyone into the courtroom without a big infection risk.
So we can actually see in this case how culture directly influences law, especially when we have to work with an extreme situation. Unfortunately, we already came to the end of our podcast. Thank you for being here. Unfortunately, we can't discuss this any further. Thank you for your input and your time.
Thank you.
Thank you.